Right, it's almost 1 o'clock. Could we do a mic check and video check in the hearing room?
Good afternoon, Hearings Officer Brooks. We hear you loud and clear.
Okay, excellent. And it looks like the video is already recording. All right,
That's correct.
are we ready, Mr.
We
Riggini?
are.
Okay, then we will go on the record. The time is 1 p.m. This is the hearing for Deschutes County file number 247-24209-CU, which is a request by the applicant for conditional use approval for a non-farm dwelling in the exclusive farm use zone and wildlife area combining zone. My name is Tommy Brooks, and I am the hearings officer in this matter. Before we turn to the particulars of the hearing, I'm going to turn things over to Mr. Riggini to describe how the participation process will work.
Thank you, Hearings Officer Brooks. At this time, I'm going to go ahead and share screen, put my PowerPoint up as I go through the hearing procedures. As Hearings Officer Brooks noted, this is a conditional use permit for a non-farm dwelling. The hearing will be conducted in the following manner. Again, I'll explain the hearing format. It'll be followed by a brief staff report, and then we'll enter the testimony portion of the public hearing. The applicant bearing the burden of proof will have 30 minutes, followed by anyone who is in support of the application will be provided 3 minutes. Those in opposition, also 3 minutes. And then if we have anybody who is neutral to the proposal, they will be given 3 minutes. The applicant will be given a 10-minute rebuttal period, followed by staff comments, if any. As noted on the screen, the hearings officer can amend or eliminate these time limits as he sees fit. For participation, we have both in-person and remote participation available. Before starting your testimony, please state your first and last name and your mailing address. This ensures that you are given notice of any decision issued by the hearings officer. For in-person participants, either Hearings Officer Brooks or staff will call up each person in person to testify. When you come up to testify, please come to the front center table. There you'll see a sign-up sheet. If you haven't already signed in, please do so. If you are participating remotely, you must be participating using Zoom. In Zoom, if you wish to participate, provide testimony, we're going to ask that you use the raise hand feature. So that's a button in the bottom center of the screen if you're using a computer or smart device. If you're using your telephone, you would type in or dial *9 again, and that would be to use the raised hand feature. If you have any written testimony, you can submit that testimony to me in person. If you're participating remotely, you can send that testimony to my email address. It's on the screen, anthony.raguini@deschutes.org, and that's anthony.raguine@deschutes.org. Staff and the hearings officer are responsible for an orderly and respectful hearing. Any behavior that is not appropriate to the hearing may result in that person being removed from the hearing. So we ask that everyone be respectful of everyone else's testimony. Please no comments from the audience during testimony. We must have all testimony be on the record at a microphone. At this time, I'm going to ask if anyone in person or participating via Zoom has any objections to the hearing format. If you're in person, please raise your hand. If you're in Zoom, use the raise hand feature. Hearings Officer Brooks, we have no objections to the hearing format. At this time, I'm going to stop my screen share and turn it back over to you.
Okay. Thank you, Mr. Riggini. As just described, we're going to follow the normal hearing procedures that are set forth in the county's code, and I will provide sufficient opportunity for everyone to participate at the appropriate time. This application is being considered through a quasi-judicial process. I will consider only the factual evidence that is in the record. I will then apply those facts to any relevant provisions of the county's comprehensive plan and land use regulations. The standards and applicable criteria relevant to this hearing were identified in the public notice announcing the hearing. They are also set forth in the staff report. The public notice and the staff report are posted on the county's website, and they are also available directly from staff upon request. It is important that you direct all of your testimony to the standards and the applicable criteria. If you believe a criterion applies that was not listed, you may address the unlisted criterion. However, I urge you to also explain why the criteria must apply and to do so with specificity so that other participants may respond and so that I can address that issue in my decision. The failure to raise an issue with enough detail to enable me or other participants to respond precludes your ability to appeal that issue to the Land Use Board of Appeals. Also, the failure to raise a constitutional or other issue relating to any proposed conditions of approval, again with enough detail to allow me to respond to the issue, precludes an action for damages in circuit court. As I just noted, I serve as the county's hearings officer in this matter. In that role, my job is to be a neutral decision maker. Thus, while I have a contract with the county to serve in this role, I'm obligated to remain impartial, and I do not represent the county's interests or the interests of any other participant. To that end, I'll state for the record that I do not have any relationship with the applicant, and I'm not aware of any connections I may have with other participants in this proceeding that would prevent me from remaining impartial. I have communicated with staff, but only to discuss the particulars of today's hearing and not the substance of the application. I do not have any ex parte contacts to disclose. It is my obligation to preside over the hearing in an efficient manner, so this is the time we will take a break to figure out how many people are actually signed up to testify today.
Hearings Officer Brooks, we have the applicant along with the applicant's legal counsel and a representative from Land Watch. I do not believe anyone is signed up in Zoom. Yeah, there's no one in Zoom, so we have 2 participants at this point.
Okay, great. Sounds like we can make it pretty smooth then. Before we begin, does anyone wish to challenge my ability to hear this matter or to challenge the county's jurisdiction over the matter?
No objections, Hearings Officer Brooks.
Okay, so I'll turn it back over to you, Mr. Ergini, to deliver the staff report.
Thank you, Hearings Officer Brooks. I'm going to go to share screen again. So some particulars about the subject property. It's located at 71510 Forest Service Road 6360. This property is unique in that its northern property line abuts the Jefferson County line. It's approximately 10 miles west of the unincorporated community of Terrebonne, approximately 42 acres in size. As we noted previously, the applicants requested a conditional use permit approval for a non-farm dwelling. On the screen, I'm showing the revised site plan that was submitted by the applicant. There were a number of issues that were raised in the staff report, and I guess I'm going to interject a little bit here. Just for the purposes of the recording, the file was initially reviewed and the staff report issued by our senior planner, Caroline House. She is on leave, and so therefore I'm taking over from this point as the staff contact. So if there's any confusion from anyone who is reviewing the record, Caroline House, our senior planner, is the initial staff contact, and I will be the staff contact from this point forward. Again, the staff report identified a number of issues as is shown on the screen, dealing with whether or not the study area, and typically the county employs a 1 mile study radius, whether or not that study area is appropriate, what is the appropriate characterization of the land use pattern in the area within that study area. There were some questions about clearly defining where the building envelope is located with respect to the soils units that were identified on site. Does the soil study provide enough information to make a determination that the building envelope is generally unsuitable for farming? Has the property been used for farm use in the past? Therefore, is it suitable for farm use? And finally, whether the building envelope would comply with the wildlife area combining zone standards for a dwelling. Specifically, would it be within 300 feet of a road that existed as of August 5th, 1992? I will note for the record, the applicant submitted information into the record yesterday afternoon. It's been uploaded to Acela and also shows in Dial. And the submittal addresses all of these issues that I've shown on the screen. I'm sure the applicant will provide more detail for the hearings officer's consideration during their testimony. And with that, the record is published on this website that's shown on the screen. And with that, staff is available for questions from the hearings officer.
All right, thank you. I do not have questions for staff at the moment, so we can call the applicant up for its presentation.
No. Stephen can move the camera.
Hello, Lisa Andrak on behalf of the applicant with Fitch and Neary, 210 Southwest Fifth Street, Redmond, Oregon, 97756. So I did submit a number of materials yesterday responding to the staff report, issue by issue, really, right, as raised in the staff report. And I do apologize for submitting that yesterday and not previously, in more time for your review in advance of today, but I wasn't able to submit it until yesterday, so I apologize for that. But I did go through and address some of the concerns or questions that were raised in the staff report, and I hope that the record now is substantial and supports the questions and the findings that are needed for approval here today. I know that we're not asking you to rubber stamp an approval from 2009 or even the 2014 approval. But what is interesting is that a lot of the analysis that was applicable there is still applicable today. The circumstances, the facts, the on-the-ground situation has not really changed for that area since 2009. So what ended up happening in 2009 was that this parcel was partitioned. It was originally an 82-acre parcel, and the county approved a partition to create two approximately 40-acre parcels, and this being one of them. And the county approved a non-farm dwelling on this parcel. The other property, the other parcel already had a dwelling, so it qualified as a non-farm or a dry partition, but the county also then approved this as a non-farm dwelling as well. As part of that application, the applicant submitted a soil study done by Roger Bereen, and he classified the soils as primarily class 7 for the parcels and a small area of a class 4. The property is not irrigated, and he said that the class 7 soils were pretty shallow and primarily rocky. And in his report, he indicated that it didn't matter whether they were irrigated or not, they were still class 7s. The building envelope for the area is all entirely within the class 7 soils in the southwest corner of this parcel. There is no irrigation on the property, and it has not historically been farmed. They do not receive farm deferral. It's just, and you can see through the history of the 2009 application and the 2014 application that the record shows that the property was not farmed. It has not been farmed. Even the prior owner, there was no indication that he farmed it either. Even though he had a larger farm or ranch, he didn't farm this parcel either. So the property was partitioned in 2009, and it was approved as a non-farm dwelling, and then that expired. So the applicant came back in 2014 and submitted another application for the non-farm dwelling. It was again approved, based primarily on the same facts and circumstances. The 1 mile study was used in both applications and findings, finding that the 1 mile study area was appropriate. And the type of use in the area, it has not really changed. It's still large tracts of open range land, primarily not irrigated. There are large tracts of public lands owned by the United States. And there's one larger ranch operation and farming operation that primarily uses all those public lands for their grazing operation, and that's the Long Hollow Ranch. They submitted a letter in the record here to support the application, saying that this proposed dwelling will not impact their ranch or farm operation. In addition to their ranching, they have a lot of the grazing allotments that they use on the public lands, and then their own lands. They do have some irrigated fields where they have hay production. Other than that, there's really no other farm operation in the area. So there are some parcels that have been developed with dwellings, I think the development of dwellings has been pretty much exhausted as far as potential new dwellings. I don't really think there are many that could be approved. I think all of the dwellings that have been approved since 1993 have all been non-farm dwellings. And there really don't seem to be parcels that could be further partitioned for development. In Jefferson County, they don't allow division of parcels for non-farm dwellings. The holdings in Jefferson County are primarily large tracts held by either Deschutes Land Trust, which one of them has a large conservation easement on it. And Deschutes Land Trust, it holds it for conservation purposes, so they don't develop with dwellings. And they wouldn't subdivide their property for that purpose. But in the rangeland, you can't divide it for dwellings anyway. The other holding is by a trust. They have large tracts. I'm not really sure exactly what their purpose is, but it seems to be to preserve the lands and open space because they haven't submitted for or developed any of their land holdings. And then the balance is owned by the United States government for public benefit. And then there's one dwelling in Jefferson County on a private parcel, and it is not receiving special assessment. It was disqualified from the special assessment when it received the non-farm dwelling approval, and that was in 2002 or 2023. I'm sorry, 2022 or 2023. So that's what Jefferson County looks like. It's still, I mean, it's open lands primarily. There's one dwelling on the 1 mile study area over there. It's dry ground. There's no irrigation on that side of the 1 mile study. And there doesn't seem to be any new dwellings that would be proposed or approved, or any new parcels. And an argument to say expand that perhaps because there's only 21 tax lots in the study area, that may not be enough. It wasn't enough twice before where the study area seemed to represent the uses in the area. Here, expanding the study area would only really just incorporate more of the same large tracts because the parcels are large. So if you expand the study area, you're just incorporating more of that same tax lot. So it doesn't necessarily increase the number of tax lots. And the argument that I submitted in my materials yesterday was that it's not about the number of tax lots that are within a study area. It's really about representing the area, the uses in the area, and what impacts, if any, there might be from this dwelling on farm practices. Would it force a change or significantly increase the costs of farming? And we submit that as previously decided twice. That is not the case. This non-farm dwelling is not going to negatively impact farming. Mr. Boreen passed away, so we weren't able to contact him for his input here. So we are relying a lot on his prior soil analysis that he did for the 2009 partition, which is still relevant and valid. He also had submitted some information about the forage, the AUMs for the subject property, the class 7 soils. And the county had previously twice found that there's not enough AUM to support a farm use or farm operation on the subject parcel. But here, because we are only focusing on the building envelope for suitability, the class 7 soils clearly do not support farm use in the building envelope. With that, I don't really have anything further unless you have any questions.
Yeah, thank you. I do have a few follow-up questions, and I did see that you submitted something yesterday. I was able to just barely open it today, so maybe some of it's answered. But just so you can, I still want to ask these questions just in case. The first one's on the farm practices, and this is 18-16-040, kind of the primary criterion here about not having a significant change on farm practices. The application seemed to kind of reverse that a little bit, and it said the farm practices in the area won't affect the dwelling. But I think it's the other way around. I'm supposed to make a finding whether or not the dwelling will affect the farm practices. And I think you recapped today some of the supplemental information, which was that there's only one really farm use. But is there somewhere in the record I can go look and see what the practices are that are associated with that use, so I can make findings about the practices, the farm practices?
There should be, Deschutes Hollow, they submitted a letter, I'm sorry, Long Hollow Ranch. They submitted a letter saying that they operate the grazing operation in the area. There's also evidence in the record that they have irrigated pasture or hay fields. So those are the only farm practices in the area. There's nothing else happening in the area as far as farm practices go. That information is in the record. There's several places where it's discussed that there is dry, open range grazing happening in the area, and that there's just those irrigated fields in the southeast area of the 1 mile study. So that should be in the record now. And I do understand that it is the impacts from the non-farm dwelling on farm use. And I think when the applicant originally submitted the application materials without representation, and I think they may have had that a little bit reversed.
Okay. So, and I did read that Long Hollow letter, and I think you probably answered it in your supplemental from yesterday, but just to confirm, I mean, I actually initially read that letter too to say that there was a grazing lease on the subject property. It sounds like there was not. So I just want to confirm what the history of this property is, if there's a grazing lease, and whether or not there's been any grazing on it in the near past.
No, so the applicant actually owns several parcels in the area. They do have a parcel, not this one, that Long Hollow Ranch uses for grazing. It's open range grazing in the area. So this parcel has not historically been used for grazing, except for maybe if cattle came onto it for some reason, but it was not leased. It's not been engaged in a farm operation for grazing purposes, and it's actually fenced off. So in the open range, you have to fence out the cattle, and it's fenced. So it is not used for open range grazing either. But no, it's not historically been used as a grazing operation or a lease or anything like that.
And then one question I had, and I don't know if it's relevant, but I was trying to figure out where so this was part of tax lot 100 as well. Is that to the east or to the west of the subject property? Like, what was this carved out of?
Oh,
I couldn't
Yeah.
define it from either the print was too small, or I just didn't see like a good tax lot map.
of the original partition.
Yeah, just because since that was kind of addressed, I mean, since the soil report talked about the larger parcel, I'm just trying to spatially figure out where the larger parcel was that this one was partitioned from.
Okay, so I'm looking at the partition plat 2015-4, and I actually had contemplated putting it in the record and then wasn't sure that it was going to be necessary. So I didn't, but I have it here conveniently. It was parcel 100, no, let's see. It was parcel 300 and 301, I believe, in that original partition. But I'll submit this, I'll hand this to Mr. Regini and include this in the record, and you can see the partition plot for this. From the plot itself wasn't recorded until 2015, even though the decision for it was back in 2009.
Okay, that would be helpful to have that thing, just
Sure.
the picture.
Yeah, I had to dig it out myself.
Can you, and then tell me more about the road that's on site? I too was trying to figure out if you were referring to the Forest Service road in places, or what might be turned into the driveway. So can you just kind of re-anchor me on what the existing roads and access to the property are?
Yeah, so Forest Service Road, I think it's 6360. It goes north and south. And that's a Forest Service road, so they have an agreement, one of those Forest Service permits to use that for access, which is in the record. Off of that, it's an unnamed spur. So I think they just kind of refer to it as Forest Service Road, the same number, but it's a spur off of that. And it shows up in the 1985 aerials as well. But it goes east to west and it goes all the way to their property that they have even further west of this parcel. The property to the west they own and also have a dwelling on it. So this is just like an old spur, a dirt road, that's been used for a long time in that area. And it shows up in the old aerial photos, but it's unnamed.
Okay. Is there anything that establishes kind of the permanence of that road?
What do you mean?
I mean, well, it sounds like maybe I guess that's to the west, that that development to the west uses this road or, um,
Yeah, it's the access road they use as well to get to the dwelling on the parcel to the west, which I believe is tax lot 100. So it traverses the southern boundary border area of their properties and they own both lots. But yes, it goes across this parcel, tax lot 300, to parcel then other parcel to the west, which is I think tax lot 100, and it provides their access, which also uses Forest Service Road 6360 for access
does
in
that
south
parcel,
direction.
sorry to interrupt, does that parcel to the west, I mean, what's its right to use that road? Is it because is it an easement? Is it, um,
Well, it's not an easement at this point because it's in common ownership, so we can't do an easement when you have common ownership because of the merger issue. But if either parcel was ever sold, it would be an easement, right? That would need to be recorded. But yes, right now it's permissible.
and then the last question on the road is the version of the BLM right-of-way assignment and the underlying certificate, I guess, that I saw. It says it expires in 2041. Is there any meaning to the fact that that's not a permanent access along that road?
No, the government doesn't do permanent accesses. They only do permits that have a certain length of time. I'm not aware of them ever doing one that's for a permanent right to use.
I think one of the criteria that I'm tasked with addressing is whether or not the access is sufficient to the parcel. So I'm just trying to get detail about the sufficiency of that, I guess now and in the future.
Well, I know they've historically approved it. It is a public access way, but they do have an existing permit for that use.
And then just a couple, I guess, clarifications. And again, this may be addressed in your supplement that I haven't read yet. But I think the way, if I understood it right, the way that the staff report was maybe taking issue with whether or not the percentage of the class 7 soils, what that percentage was to this property compared to I guess the larger property that it was carved out from. So is that clarified in the record in terms of the exact percentage of class 7 soils on just the subject property?
It is. As I said earlier, we're looking at the suitability of the building envelope, not the entire parcel, but I still did clarify that the class 7 soils are more than 50% of the parcel. The larger parcel that was partitioned was about 82 acres in size. Most all of the class 4 soils were allocated on this parcel. So even using 100% of the class 4 soils in the computation, the class 7 soils still exceed the amount of class 4 soil. So there's more than 50% of the parcel is made up of class 7 soil. And I did lay that out in my supplemental submittal. But yes, we are also only looking at the building envelope as well.
And then I think I understood from your earlier presentation, this is just, I don't want to leave this loose end, but the study area for both farm practices and the blanking on the code section, but the 1 mile radius, it sounds like the 21 or however many tax lots that you identify constitute the entirety of that area, as opposed to there being gaps within that. Is that
I believe the 1 mile study area, which includes Deschutes County and Jefferson County, consists of at least 21 tax lots. That's 21 tax lots that somehow encroach within that 1 mile study area. I'm not sure if that answers your question.
I think so. I think the reverse would be if you were to take that 1 mile study area, there's nothing that's missing in that pie. If you look at those tax lots that you looked at, that actually does cover the whole study area.
It does, and I think it's a good representation because it has both smaller parcels that are developed with a dwelling and not engaged in farm use. It has larger tracts that are engaged in open range or grazing that are also dry. Then it has a little parcel area that's irrigated and has some farm use, and then it has large tracts of open publicly held land. So I think it's a good representation of the mix of uses or potential impacts that the non-farm dwelling could have on the surrounding area, all within that 1 mile area. And there are no known or there's no evidence of any negative impacts within that 1 mile area.
Thank you for clarifying that. I think my last question, and this had to do with the proposed condition of approval for fire protection. The only thing that stuck out to me on that I questioned was is in the fourth paragraph of that condition, and it's subparagraph B, and it requires that the dwelling shall have on-site water storage capability from a swimming pool, pond, or lake of 4,000 gallons. I'm just wondering, what struck out to me was if there's any meaning behind the word capability as opposed to just saying shall have on-site water storage. Because I don't know, I guess the skeptic in me says rely on a pool and then the pool's empty. Does that really offer you the fire protection? You had the capability of the storage, but not the actual storage. So I just wonder if any thought went into that piece of the condition.
Well, I mean, the applicant's willing to put in, a cistern if they need to store that kind of water. A pool, yes, could be empty during the year and a cistern might freeze, but I mean, they also have wells within the area that would be able to be used to suppress a fire, and state law doesn't prohibit that. So, I mean, they're willing to use whatever means they need to in order to have the necessary fire suppression, the water available for that.
Okay. Okay. That's all the questions I have for the applicant.
Okay, thank you.
Thanks. So it doesn't sound like it sounds like there's only one other person signed up for testimony.
I just want to confirm with the applicant, there's no one else on your behalf? Okay, yeah, so the applicant has completed their presentation. There is only one person. I want to confirm with Stephen, no one on Zoom. Yeah, so we have only one other person who is here to testify.
Okay, let's have that person come up.
Good afternoon, Hearings Officer Brooks. My name is Rory Isbell. I'm a staff attorney with Central Oregon Land Watch. Our address is 2843 Northwest Lolo Drive, Suite 200, Bend 97703. I do have some written comments. I just emailed them to Anthony at the beginning of the hearing. I've got a few paper copies. I'm going to hand one to Anthony now and one to the applicant. I know you haven't seen these comments yet, but I'll take my few minutes here to run through some of the salient points. We do oppose this application. We don't believe it meets the applicable criteria. It's already been referenced, but a lot of the evidence in the record to support this application is from many years ago. We don't think it reflects current conditions on the ground. That shows up in what we just talked about, the size of the study area and the description of development and potential for development in that area. Things have changed a lot since those 2009 applications. In my written comments, I include a couple aerial photos. One is on page 5, which is from 2014, and it shows no dwellings in the area. And then on page 6, there's the most recent aerial photo I could find, which is from last fall, and it shows 4 new non-farm dwellings developed in the area. So we do think the stability of the land use pattern in the region of this subject property is unstable and will become more unstable should this application be approved. Similar argument goes for the farm impacts test, which is of course imposed by statute and included in the Deschutes County's code as well. There's really just not sufficient information in the record to make the findings that test requires. So that's, detailed descriptions of neighboring properties, farm practices, farm uses occurring on those properties. We don't believe that this property is generally unsuitable for production of livestock. As has been talked about, there's a letter in the record from a large commercial rancher that says the grazing lease that they maintain on the Deschutes property, on the applicant's property. Now, I know we just heard testimony that might be referring to another property owned by this applicant, but the test here is suitability. So, I would posit that if a property owned by the same applicant in the same area is suitable for for grazing by lease by Long Hollow Ranch, then the subject property here surely is as well. Kind of back to the soils. 100% of the soils of this property are actually high value farmland if irrigated. I know it doesn't have irrigation water rights, but most of the agriculture that occurs in this region is through groundwater. So even though there's not an irrigation district with surface water that serves this area, another map I include on page 9 of the comments, all the properties in pink there, including many very near the subject property here, use groundwater, have groundwater permits for agricultural irrigation. Aside from the water availability, the soil study that's used in support of this application, as we've heard, is from 2009. So it's very old. There's actually an administrative rule that prevents the use of pre-2011 soil studies to supplement, soil information provided by the NRCS in this type of land use application for a dwelling on farmland. So really the only valid soils information in the record is that of the NCRS. And the NCRS says that 100% of this property is class 3 if irrigated, and class 4 without irrigation. Class 4 is about as good as soils get in Deschutes County. On page 8 of our written comments, there's a map from Oregon Explorer. It uses NRCS data. The interface there is very easy to see, so I used it. It's sort of hard to see in the written comments, but there's just a little bit of the pink or purple color on this map that shows all of the class 4 unirrigated soils that exist in Deschutes County. And right here where the subject property is located is just about the only place in the whole county that has this high quality of soils. So, some of our most productive agricultural areas in Deschutes County out near Alfalfa, near this property in the Lower Bridge Valley, have lower quality soils than the subject property here. So it's eminently suitable for farm use. There's testimony from an area rancher that either this property or another one in the area owned by this applicant is suitable for farm use. There's also a statement elsewhere in the record, might have to cite it and maybe perhaps an open record submittal that does describe past grazing on this property as well. I believe that's from one of those previous land use applications. There's also a statement on the current land use application for the applicant confirming that 100% of the soils here are class 4. A couple other points to make. You mentioned, hearings officer, the conditions of approval concerning fire breaks. We don't believe what's been proposed is adequate. The county's criteria here requires findings that fire services are adequate for the use. The fire breaks and other site design conditions that were just discussed, those aren't fire protection services. That's just site design elements. So, we believe, the county's criteria here requires fire service adequate for the use. This area experiences frequent fire. On page 11 of our comments, there's an outline of the Grandview fire that burned very near, about within half a mile of this subject property just a few years ago. It's likely to burn again. Really, for the safety of life and property, actual fire protection services should be required for this application. Final point, this property is also in the county's wildlife area combining zone, and the key criteria of that combining zone does require any new development to be sited within 300 feet of roads that existed in 1992. The proposed building envelope here is more than 300 feet away from the Forest Service Road 6360. And the driveway or spur road that's been referenced, there's not evidence in the record that shows it was in existence in 1992. There is a claim of a 1985 aerial photograph. We couldn't discern a road on that photograph, and there's also nothing that we could see on that photograph that tells how it was acquired, the date it was acquired, and the county's code on this point does require affirmative evidence on behalf of the applicant that substantiates that any aerial imagery used was produced before that date in 1992. So that sort of concludes my points. This property is about as suitable for production of farm crops and livestock as it gets in Deschutes County. The road issues, the changes since 2009, the fact that the soil study predates 2011, so state rule says that we can't rely on it. A lot of reasons why we believe this application should be denied. That sort of concludes my remarks. I'd be happy to try to answer any questions you might have for me, Hearings Officer Brooks.
I don't think I have specific ones. Is the citation you mentioned to the OARs about the soil studies, is that in your written materials?
Yes, it is.
Okay. Thank you. That's all I have for you.
Thank you.
So we can invite the applicant back up for a rebuttal period.
Thank you, Lisa Andrak, on behalf of the applicant. Okay, so I understand that the 1985 aerial photograph from the 1 mile study packet that we paid for, that was paid for and submitted with the original application, includes a 1985 aerial that the county produced from its records and was part of that packet that then gets turned in with the application. And on that, you can see the spur of this road, and it's also an old power line road. So it has been in existence for a very long time, before 1992. And the evidence in the record does show this road. The testimony by Landwatch misstates the actual language in the county code concerning the wildlife area requirement for siting within 300 feet of a road that existed on August 5th, 1992. The actual language of the code, the text, which is controlling, and that was recently decided twice now by the by Land Use Board of Appeals and the Court of Appeals, that the text is very clear in that provision, and it says that the building envelope is not what is measured. It's the footprint of the dwelling and the components of the dwelling. It says specifically that those are what are supposed to be within 300 feet of the road, not the entire building envelope. It does not The language of the code does not include the septic system or any of the other components of the dwelling. It says the footprint of the dwelling. So he overstated the language and the implications for that provision in the code. So the building envelope can be larger. It's just the footprint of the dwelling itself and all its accessory components that need to be within 300 feet of the road. And as you can see on the proposed building envelope plan, the proposed dwelling will be within 300 feet of the road. The soil analysis for the property has not suddenly changed in the last 10 years or 20 years. The soils on the property are constant and stagnant and were classified by a professional in 2009 as consisting of class 7 and class 4 soils. The NRCS is a guide as to what soils may be on a particular parcel. They have a very broad view of things when they're doing their soil classifications and not an on-site evaluation. Here we had an on-site evaluation of the actual on-the-ground soils and they were classified as class 7 and class 4 by an expert. So if I would argue then in response to the allegation that you can't use a pre-2011 soil study, that the NRCS soil data here is also before 2011. So I would say that it equally applies and says that those analysis would not be relevant here either. But I would submit that the on-the-ground study, the soils are consistent with what they were in 2009, and they're still considered class 7, not only because they were shallow, but because they were primarily rocky as well. So that condition hasn't changed on the property either. With that, I really don't have anything further unless you had questions.
I don't have other questions for you. So before we talk about next steps, I want to see if staff has any comments based on the testimony. And of course, Ms. Andrick, I'll turn it back to you if you need to respond to anything that staff says. But Mr. Regini, is there anything staff would like to add to the record at this point?
Not at this time, Hearings Officer Brooks. Thank you.
Okay. All right. I think we can wrap up here unless there's any procedural issues that need to come in front of me.
No, I think it's really a discussion of the open record period, if any. I didn't hear a specific request for an open record period.
I
So
did
I
not
don't know.
either.
Lisa, if you have a specific request for an open record period. The applicant does not request specifically an open record period. And Rory, I didn't, and I just asked the representative from Land Watch, and Rory indicates that he also is not requesting an open record period, and staff is not requesting an open record period.
Okay, great. Then I think we can wrap up the hearing. I will close the record. And I think because of that, I don't know, Mr. Regini, you need to go over any post-hearing procedures. So we'll just go off the record here at 1:47.
Thank you, Hearings Officer Brooks.
Thanks.